Ebusianfo masan so atena se aha eye Ghanatube so ensem de edoso nya ekoso ewo oman Ghana mu ene ye kase ye beka ye mfiri hanim se adofo ensem a ekoso ebi ne yenkotie.
Suspended Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Torkornoo has taken on the committee inquiring into the petition seeking her removal, hoping to restrain it from its work until a suit she filed at the Supreme Court is determined. Now, we have details of this latest one for you. That's what essentially this means. This is a very, very interesting development in this particular case and how things are playing out. The Chief Justice, suspended Chief Justice, is taking her destiny into her own hands, taking it up to, as it were, file this an interlocutory injunction that has been done as about 3:15 p.m. earlier today. That is the time that we have on the court documents that we have a copy of. Going to show you portions of it shortly. This interlocutory injunction at the Supreme Court has been filed earlier today, seeking to halt the work of the 5-member committee established by the president to inquire into the 3 petitions against her removal from office. Later, we got to know that the petitions are 5 as we speak. Well, also, the number of suits or the applications seeking to halt this process that is underway, this one adding up by the Chief Justice increases the numbers to 5. 4 of them have been dismissed. Now, in this suit filed earlier today by the suspended Chief Justice, we have a copy of it cited by us. Justice Gertrude Torkornoo is praying the court for a number of reliefs in order to restrain the committee from taking any action in connection with the Prima facie case determined against her. We have the full details of the reliefs, quite a number of reliefs that she's seeking. We're going to go through them one after the other, but there are a few of them that we'll spend some time on because it points to something pretty interesting. And some of the reliefs she's seeking as well are contained in some reliefs sought by previous applicants. In a number of these applications as have been determined already. Now, what does that say as well of this particular one that has been filed by the Chief Justice, Dennis Poberi Wadam Esquire, with me in the studio? We're going to run through this, and it points a very, very, very interesting picture as we're seeing right now. Dennis, good to have you. Good evening. Thank you.
Always a pleasure being here.
Always good to have you join us. And let's establish this first of all. In what capacity is the suspended Chief Justice filing this application?
Well, so from what we see on the record, she's doing this in a capacity as a citizen of Ghana.
As a citizen?
Yes, whose rights have been infringed upon multiple times, and that you would see that endorsed in the application that is before the courts, also in the writ of summons that she has also filed at the Supreme Court.
Interesting stuff. Now, but I know you're going to do a recall of all the other applications that have sought to stop the process that is underway to hear the petitions against her, and then also that process seeking her removal. How many so far?
So far, this will be the 5th one, and that's in respect of the injunction applications. But mind you, for every injunction application that has been put before the court, it means that there's a substantive suit, because injunction applications do not go alone.
Absolutely.
There always has to be a case. So we have counted 5, and this is the 5th one from Justice Gertrude Torkornoo herself, Her Ladyship. And this time around, she comes as the plaintiff in the substantive matter and the applicant in the matter of the injunction application. And this is yet to be heard, as you have seen. And this will be the 5th one. We've seen the 1st, 2nd, 3rd, 4th. So the 3rd and the 4th ones were heard earlier today. We'll come into that matter.
Absolutely.
But what we're having to deal with now is this injunction application by the Chief Justice. I mean, there's still not been a date when this will be heard, but it's been filed. We have the injunction application. I have a copy of the writ of summons itself. So basically, this is what you see, and the relief that she's seeking generally.
Very interesting stuff, and let's get into that.
Yes,
maybe.
But first off, let's establish who the parties are, because this presents a different dynamics to what we have seen earlier. Because in the earlier suit, you would see that it is the Attorney General, or in some instances the Attorney General, and then the chairman of the committee, that is his lordship Justice Poamang, And in today's one, there was an addition of Justice Gertrude Torkornoo herself as a defendant. However, what we see here, it now adds all the members of the committee as respondents in the injunction application, and of course defendants in the writ of summons itself.
And that's in her ladyship Gertrude Torkornoo's interlocutory injunction application?
Yes.
These are the respondents?
These are the respondents.
The Attorney
So
General.
in addition to the Attorney General, you have Justice Gabriel Pwamang, you have Justice Samuel Adibu Eseidu, you have Daniel Yademolevu, you have Major Flora Dalugu, and you have Professor James Sefa Jifa. These are the respondents in this injunction application.
But these are the members of the 5-member committee?
Yes, so take out the Attorney General. The rest are the members of the committee that has been put together by the President together with the Council of State to inquire into the petitions that are seeking the removal of the Chief Justice, now suspended. And that is actually the reason for which we are having to deal with this particular matter. Let's look at what exactly she wants by way of this particular injunction.
Right.
Who should be injuncted and what exactly? So, one, that she wants a restraining order directed at the committee set up by the President to inquire into the 3 petitions against the plaintiff composed. So it mentions all the respondents in there who are the committee members. From proceeding with an inquiry, taking any action in connection with the determination of a purported prima facie case made against the plaintiff. Purported prima facie case made against the plaintiff. When we begin to talk about what happened in court today, we'll put this into proper context. Just so our viewers can appreciate what's already happening.
Absolutely.
Now, there's another one, a relief.
No, but then let's go back a bit. Does the use of the word purported mean in any way that her ladyship Gertrude Torkornoo does not appreciate or acknowledge the fact that a prima facie case has been established against her?
It would appear so. And I say so because in court today, in one of the injunction applications which was brought by the CSO, which is Center for Constitutional Center for Citizenship, Constitutional and Electoral Systems.
Absolutely.
In which the ladyship was the second respondent. There was an issue where her lawyer indicated that the crux of their matter was that there was no prima facie case determination made against her. And they were categorical about that.
I see, but then that would raise a number of questions.
Even though the applicants in that matter, the CSOs, the lawyer, their argument was that, yes, they acknowledged that there was a determination of a prima facie case, except that the determination was not served on her.
Yeah.
And to that extent, they said the whole process was a nullity. That was the crux of their argument.
I see.
Now, the Chief Justice lawyer, who seemed to agree with the arguments of the applicants, and that's the CSOs, say that yes, for them, they do not even acknowledge that
there was a prima
facie case. And it took quite some time to make that argument. But of course, there was a point where there was a measure that yes, indeed, the arguments you are making fall in line with that of the applicants. But they insist that as far as they are concerned, there was no determination of a prima facie case. And they argue strongly that for a determination to be made, certain things have to be done, including giving reasons. And to the extent that there were no reasons given to them as to how they arrived at that conclusion, and even with the petitions, which ones ended up making the prima facie case, and even with the allegations in which of them, that to that extent, they do not think a prima facie case had been established. And more so, they say they did not get a copy of it. So the question was, if we do not get a
copy of the prima facie case,
what exactly was she supposed to be responding to? So that was the argument that the lawyer was making then as a defendant in this case. So from that point, it already gives a clear picture of how lawyers for the Chief Justice are proceeding on this particular matter.
Which has resulted in what we're saying.
So it's not surprising to see this relief describing the prima facie case determination as purported. And Alfred, just to add, the argument was premised on the fact that they only saw a communication of the purported prima facie case determination from the presidency.
I see.
So they make reference to the letters that were issued from the presidency announcing the determination of the prima facie case. They say that cannot be the prima facie case, but that was just an announcement of a purported prima facie case determination. It was quite an interesting one in court today, Alfred.
You sat through that court hearing.
Yes, I did.
But let's flip through the next.
Yes, so the next is an order restraining the second and third respondents from presiding over. Now, second and third respondents, let's go back. Yes, so we appreciate this. Now, second and third, Justice Gabriel Palmer and Justice Samuel Adibu Esedu, these are the two that, beyond seeking to restrain the whole committee, she specifically wants these two to be restrained.
Why is that?
We'll find out later. But she makes the case that in the case of Justice Gabriel Palmer, that he had made decisions in favor of one of the petitioners, who is Daniel Ofori. And to that extent, he does not qualify to chair the committee or even be a part of the committee. In the case of Justice Samuel Edibu Esedu, you recall that the first time the MP for Old Tafo went to court to seek an injunction in this particular matter, the original panel that was constituted, Justice Samuel Edibu Esedu was on it.
Was on it.
It is the Chief Justice's argument that for the fact that he was part of that panel, right from the word go, to determine an injunction application against a matter that she was involved in, that also disqualifies her. But Alfred, remember that at the day that that application was dismissed, lawyer for Vincent, who is in the person of the former Attorney General, Godfrey Yabo-Adami, made that a point. The two preliminary objections that were raised were to the fact that they were against the reconstitution of the panel. One. True. And also against the chairperson of the panel. Yes. But the point to be made is that this was the reason that that objection was raised.
And that's what the Chief Justice
did not understand why
citing now.
The panel should be reconstituted.
So Godfrey Yabo-Adami was a lawyer for Vincent Assefuah in this particular case.
In that matter.
Case that was
precisely so.
Who is the lawyer for the Chief Justice in this particular interlocutory injunction?
Okay, so let's separate the matters. In this particular one, as in, okay, so this is the one that is here to be heard. It is still the former Attorney General, Godfrey Yabo-Adami. However, in the matter that I just described and referring to lawyers who were or a lawyer who was representing her in today's matter, it was an entirely different lawyer. Yes,
but this particular one is Godfrey Yabo-Adami.
Yes, in this particular one, it is
for the Chief Justice.
Yes, for the Chief Justice.
Okay, let's flip to the next.
The third relief that she seeks is an order suspending the operation of the warrant for the suspension of the Chief Justice purportedly issued by the President under the Constitution. So this basically talks about the suspension warrant that has been issued, for which the Chief Justice is now under suspension. Alfred, again, let me indicate that this matter came up again in court today because there were two interlocutory injunctions that the court had to decide. First was the one from the CSO and the other one from Theodore. Now, when Theodore, the lawyer for Theodore, started to move his application, the presiding judge, who is the acting Chief Justice, drew his attention to the fact that, because as of course one of the reliefs was to suspend the suspension of the Chief Justice, it had to do with the same warrant thing. He drew the lawyer's attention to the fact that they had made a determination in a matter with a similar relief. But the lawyer's argument was that, yes, he acknowledges that, yes, that determination was made, but his arguments are different. So they asked him to move on. Just when he started, then Justice Amadou Tanko intervened and said that he offered an advice of some sort. That, yes, because their full reasonings are not yet out, and that, of course, in the case of the Vincent, the day given for the full ruling to be out would have been today. So he said one would have thought that under the circumstances, since you have similar reliefs and seeking basically the same thing that the court has already ruled on, one would have thought that at least a lawyer who intends to come would actually wait to see the ruling of that particular the reasoning of the court in those matters, and if they do not address the matter that are coming to the court with, then you can tweak your argument or your relief and come. However, it was just an advice, leaving it to him whether he still wanted to continue or he could decide otherwise. But he still continued. And that's how come, I mean, from that point, it was a clear signal how that application was going to end. And indeed, it ended just like the one for the CSO. 4-1 majority, they dismissed it. So that's how things shaped up in court Alfred today. So these are the reliefs that she's seeking by way of the interlocutory injunction which has been filed.
Yes, I know apart from the 2 reliefs that Dennis highlighted earlier, there are a few more reliefs that her ladyship Justice Gertrude Torkornoo is asking in this interlocutory injunction. Dennis, what do we know?
Well, so the three reliefs that I just did a while ago, those relate to the interlocutory injunction. Now what we are about seeing are reliefs that are being sought in the substantive matter. So these that you would see, which involve some of the things that we may be hearing for the first time because there haven't been things of public record, are indicated in this, which is in the substantive matter. So the first relief, she basically wants a declaration to the extent that she has a right to a public hearing. So she cites the provisions of the Constitution that relate to everybody being equal before the law, the right to fair trial, and also the provisions that relate to the constitution of the committee and its work, commission of inquiry, and then the exercise of discretionary powers. Then there's a part where she now says that she wants a declaration that the Chief Justice can waive the in-camera nature of the proceedings under Article 146. Mind you, we have said on this show, time without number, that the whole proceeding is supposed to be in-camera.
Absolutely.
But she is saying that she wants a declaration that the Chief Justice has the right to waive that particular right that she has. I mean, or the nature of the proceedings.
I see.
Is that to suggest that there's been a request for such to be waived? We don't know.
Well,
we're only seeing this.
Because we had read some media reports that she had
seemed to suggest.
Requested that, you know, this in-camera one be put away. She wanted it telecast for us all to see the hearings of this 5-member committee. From the communication last week.
But that is supposed to be in camera.
Absolutely. From the communication last week, this 5-member committee's hearings have begun.
Precisely so. And they are ongoing.
And they're ongoing. And this, she's asking that she wants that right that she has as an accused person in this particular case.
She wants a declaration to be made that that right can be waived.
So then we would all see.
Yes.
The committee is here.
That it can be waived so that she has the option to waive or not to waive. Or anyone, not just her, but that anyone who is in that situation would have the option to waive or to stick to what the Constitution provides. And that she wants a declaration in that regard.
I see. But then what does the 146 state in dictate? The specific detail of in there. Does it give in this case, the suspended Chief Justice that leeway or the right to ask that this particular in-camera hearing within her right be waived?
Mind you, she came from a number of provisions. So when you look at all these provisions and what they provide for, 17.1, 17.1, equality before the law, 19, the whole of 19 is on fair trial, 1, 4, 6, 7, and 8. These are the matters we're talking about, the committee and its work. 281, commission of inquiry and how they should conduct their business and how the proceedings should go. 295 and all. So when you look at it, now she comes to a point where she says that make a declaration that after all these things, it should be possible that somebody who comes to these proceedings, even though the requirement is that it should be in camera, you should have the right to waive that. That is a matter entirely for the Supreme Court to make a determination on. Whether they agree or do not agree, it's a different matter altogether. And these are matters that will be determined in the substantive suit.
Well, let's stay on this. And
Ebushiafo we de wankasa ode waso ati edweni ehu nia ekoso ewo yemai Ghana mu ene me sure say comment section na fa comment no ebrem na mejebre akenkan ede ama ofefefe aha eye Ghanatube so insema ekoso ena onsa ebeka on subscribe ya subscribe na hit notification bell no for more news updates see ade akamo